Okay, so you got, what you're saying is you got a letter from Strike 3 Holdings and you own a restaurant that provides internet access and they're trying to hold you liable for somebody downloading movies at your facility? Yeah. Okay, hang on. I'm doing a video on this right now, so just check out my YouTube channel. Hi, and welcome back, Attorney Steve Vondran. Hope you guys are having a great day today. I had a question about what happens if you have a facility like a gym or a restaurant, hotel, something like that, where you offer Wi-Fi access to your customers, and then one of your customers ends up downloading, let's say, adult pornography or child pornography, okay? Over here, these people, okay, your clients, your customers. Can you be held liable as the business owner? Can you be held liable for their infringing activity on the internet? Without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, we are back. So I had this question, and it came up in a real life scenario, and I was talking with the opposing counsel, and we said, I really don't know that there is a case online, a case on point, where a bar, a restaurant, an airport, a hotel, country club, coffee shops, where these companies that provide Wi-Fi access to their users, they provide Wi-Fi access a lot of times to keep them around, so they hang out, buy more products, have a place to relax. We're seeing more and more of this these days. Question is, if these guys are down here downloading intellectual property, pictures, movies, whatever, music, these recording industries, the movie industry, they don't like when people are downloading their stuff. But what if people are coming to your establishment, downloading this stuff and then hitting the road, or 't even they're coming back on the weekend. They're sitting out there in a van going, I have the access. I have the password to get in over here. So let's just hang out in the van in the parking lot. So there's a lot of things that go on here. I've got your Wi-Fi access. The question is, Wi-Fi access liability. Can these companies, these copyright holders, these industries, the movie industry, the music industry, can they come after the owner? What are the theories of liability? Well, the two we have here, the two typical ones we see in copyright law, is one, vicarious liability, where you say, well, you're vicariously liable for them because you had a knowledge and ability to control and a financial interest in their activity. Now, I actually have not seen a case that has actually held this way. And so if you're a business owner and you get caught up in one of these types of actions, I would seek legal counsel to see, is there any case on point that would hold somebody liable under a vicarious liability theory, vicarious infringement. Now, another one is contributory, but that's not usually going to be a play. That's where you're contributing, aiding, abetting, inducing. Come on, guys, download all you want. It's free till midnight. Get all you want. So that would be contributory liability. But if you don't have these two, and many courts have said there's really not a negligence theory here, then what are you left with as a plaintiff, as one of these MPA, RIAA, company like Strike 3 Holdings, movie company? What are they left with to try to go back at this owner? And again, I just did not find, I did a very diligent search. I did not find any cases on point. So this could be an open question. This could be subject to, there could be pending case law that's just waiting to come down. We don't know. Okay. Theories of immunity. Here's your theories of liability. There's your theories of liability. What about theories of immunity? Okay. So there's two theories that I have seen in my research. One is under the Communication Decencies Act, Communication Decency Act, Section 230. This talks about a service or a system. Is this a service or a system that offers access to the internet? Arguably, they could be immune under the CDA for anything that the users post or download. Okay, arguably, I say. These are arguments that you would make. This is not legal information. This is general legal information only, so bear that in mind, okay? So maybe there's immunity there. Another one that you'll see pop up is the DMCA, Digital Millennium Copyright Act safe harbors, Digital Millennium Copyright Act, Section 512. And in order to take advantage of this type of what we call safe harbor immunity, we should write that in there, safe harbor, okay? Safe harbor is what they call it. Typically, you want to apply for a DMCA agent, and with the, through the Copyright Office, get yourself an agent, get listed. However, this is a weird situation because if they're downloading things, it's not really available on the internet. So it's not like you would send a takedown letter saying, "Hey, one of our movies is showing on your company website." If that's the case, that's one thing. But typically, you were just talking about wireless access and whether or not these people can be downloading things. Okay, so it creates some interesting questions. Now, maybe you could apply for a DMCA agent if you're one of these companies. Say, I'm a service provider. And let's read you the definition of that real quick, just for those of you who want to know. What is a service provider? Of course, to have this safe harbor, you have to be a service provider. Let's look at the law. As used, and now this comes from 17 U.S.C. 512, K as in crackle, 1, Section 1, K1, okay? Any of you Chevy fans, that's a K1, like the K1 Blazer. As used in subsection A, the term service provider, can they be deemed a service provider? Means an entity, okay, offering the transmission, routing, or providing of connections. Are they providing connections here? For digital online communications. Are they providing the connections for digital online communications? Seems to me they are. Between or among points specified by a user of material of the user's choosing without modification to the content of the material as sent or received. So there is, and I have seen online, there are arguments, and especially I found in the UK, arguments to this degree that you can't come in and just hold these people liable for providing just a Wi-Fi access. And if these people are abusing, maybe you need to go find out who they are or go after them, or maybe there's just no liability at all. Who knows? So that's what we're talking about here. Service provider provides connections for digital online communication. So you have these two theories, potential immunity, CDA, DMC, if you're one of these types of entities that are providing the Wi-Fi access. Now, some tips I would say, if it was me and my company, I would probably look into getting this DMCA agent. If I have a website, maybe I would post the agent on my website just to have it. Is something that I would be looking to do. Also, as you see when you go to hotels sometimes, they'll have you log in on a splash page. So you put your name and your number. So if something does go wrong, many times they can track it back to you. So you could have a splash page with disclaimers. You ought to periodically change your password so you're not just letting people roam free, coming back a month later and using your password in the van in a parking lot. You might want to have a repeat infringer policy. If we catch you doing something, you're not coming back in our shop. We're blocking all access. So these kinds of things are not an exclusive list. These are some things that I would be doing if I were the business owner and I wanted to provide this access, but I didn't want people to infringe and get me busted for what they're doing, okay? So that's what we're talking about here. I would say if you're getting a letter from one of these companies seeking to enforce their intellectual property rights, those kinds of things, they're coming back at you for liability, I would seek a copyright attorney. Here's one you can find right here, a good one that I know. AttorneySteve.com. That's AttorneySteve.com. That's us. And let's take a look at the case. I would be asking for the case law if I'm fighting another attorney. I'd be asking for their case law that makes you liable, for providing the Wi-Fi access, okay? So that's a little bit of torrenting law, BitTorrent, downloading, sharing things. We're seeing a lot of this stuff. Strike 3 is out, hammering people again. Lots of infringement cases, piracy. You know where to find your copyright defense group right here at AttorneySteve.com. All right. Hope you guys are having a great weekend. Enjoy the rest of your day. I'll be back with more great stuff this week, I should say. So stay tuned. Thanks for watching. Have a great day.